So, ladies and gentlemen of the media, my fellow countrymen and women, I am here this morning to account to the sovereign people of Ghana, as has been my practice since assuming office as Attorney General. On Tuesday, 22nd July 2025, I took the decision to enter a nolle prosequi in the case of the Republic versus Duffour and 7 others. This decision effectively brought to an end the criminal trial of Dr. Duffour, a former governor of the Bank of Ghana and former Minister for Finance. I took that decision after a prolonged period of negotiations with my team of state attorneys, including the Director of Public Prosecutions and the receiver of Unibank on the one side. The team on the other side was made up of Dr. Duffour, the shareholders, directors and managers of Unibank, and the receiver. As part of my constitutional duty to account to you, my fellow countrymen, I wish to provide further details on my decision for 2 reasons. First, I have always maintained that as your Attorney General, I owe you a duty to act transparently. Second, I think it is important to dispel certain misimpressions that arose as a result of the rather terse press release that are issued following the filing of the nolle prosequi. My fellow countrymen and women, in March this year, the lawyers for the Unibank directors and shareholders approached me with a proposal of their clients' intention to settle their indebtedness to Unibank. In response, I convened a meeting on the 25th of March with them, their legal representatives, and the receiver of Unibank, Mr. Ni Amano Dodu. At the meeting, it became obvious to both parties that a reconciliation of Unibank's account with the Bank of Ghana should be conducted. Therefore, I authorized the receiver to engage in the reconciliation exercise with them to determine the full scope of Unibank's exposure. I directed that the parties adopt a holistic approach that combined liabilities under both the criminal proceedings and the ongoing civil proceedings, because they were obviously interrelated, in order to reach a unified resolution that will bring closure to all related matters. In assessing the proposal submitted by the lawyers for the accused persons, I took into account the following factors. The receiver of Unibank acknowledged that the fictitious amounts totaling 2.1 billion did not result from cash outflows, but related to accounting entries that overstated the asset base of the bank, which predated Unibank's placement in official administration. B, a claim for the placement of 0.3 billion with the SEC-regulated entity was filed by the receiver with the official liquidator in 2019, and its recovery is being pursued separately through the insolvency process. 3, both the criminal and civil cases have persisted over 6 years with no immediate resolution in sight. The complex nature of the legal proceedings has significantly delayed any meaningful recovery. Now, come to think of it, those who instituted the criminal proceedings did not foresee the possibility down the line of recovering assets and never engage in any asset recovery process. They did not trace, to find out what assets were in the hands of third parties, including those who were in court. So while the criminal prosecution was intended to serve as a punitive and deterrent measure, it is through the civil process that actual recovery of funds is effectively pursued. The accused person's proposal fell within the receiver's mandate to maximize recoveries for Unibank in order to settle the bank's creditors, mainly Government of Ghana and some institutions. There is also a genuine risk that prolonged litigation could ultimately lead to lower net recovery, especially when accounting for legal costs, procedural delays, the time value of money, and the potential dissipation or concealment of assets. By contrast, the current arrangement secures the timely resolution or recovery of over 800 million Ghana cedis in assets and establishes a structured pathway for recovering an additional 1.2 billion Ghana cedis with the active cooperation of the accused persons. On the other hand, should the matter have continued in court, it would likely have faced prolonged delays, including multiple procedural applications, adjournments, and appeals. Even if judgment were eventually obtained in either the civil or criminal proceedings, enforcement and execution could take years, further deferring any meaningful recovery. It is clear from the foregoing that I took a pragmatic, holistic approach by engaging the receiver and the accused persons to broker a resolution that settles both the criminal and civil dimensions of the case. This strategy recognizes that while criminal proceedings are punitive, the real economic value to the state lies in a non-conviction-based asset recovery approach. The terms of the settlement are structured to ensure that the Attorney General, the Bank of Ghana, the Minister of Finance exercise oversight over the recovery of the negotiated amounts. Progress under the agreement will be subject to quarterly reviews to ensure that the accused persons fulfill their obligations as agreed. Ladies and gentlemen of the media and my fellow countrymen and women, it is important to correct certain misunderstandings or distortions, deliberate in some cases, that our team picked from the media space regarding this matter. Since my press release, it has been said that by setting a minimum threshold of 60% for the recovery of assets as a condition for filing a nolle prosequi or terminating the banking sector cases, I have cut a deal which permits persons who have stolen or looted public funds to walk away with 40% of the loot. At least that is the narrative, by some sections of, the Ghanaian populace, particularly from our opponents in the MPP who were responsible for all this mess. Indeed, one writer on Facebook compared my decision to the situation where someone has stolen 6 goods and is being told by the prosecutor to return 4 goods and keep the 2. But my fellow countrymen and women, now this may seem like a joke, but it's a very serious expression of the sense of justice of our community. And it is something that I have used, to, get people who have come to me for plea deals to get them to think about the community's sense of justice. So, it is not lost on me, and I wasn't surprised when I read this on Facebook. But the goat thief analogy, intriguing though it may be, is an oversimplification of the matter. This is why. First, Dr. Duffour and the other persons standing trial were not charged with stealing or looting of public funds. They were charged with causing financial loss to the state, fraudulent breach of trust, falsification of accounts, as I have pointed out earlier, dishonestly receiving, and money laundering. But the facts and the evidence supporting these charges never allege that those standing trial personally benefited from the banking transactions that gave rise to these charges.